happy Monday. You know what that means. It is time for Bring the Jury. I'm here with Luke and Bryan Sheely of the Sheely Law Firm. We're here in Columbia, also offices all the way in Charleston and everywhere in between. Not offices, but services. Quick recap.
And offices with rent that must be paid and staff and
all the things.
Power bills.
If you are joining us from last week, we talked about Rex Heuermann, Gilgo Beach killings. A lot more has kind of unraveled and come to the surface since then. So we're going to touch on that today as well. And if you've been following us while we talk about Bryan Kohberger and the Idaho 4, great news. We're also going to talk about that today. So a little 2-for-1 today. You can always follow us on Instagram, Facebook, YouTube, TikTok, all of the social media platforms, and learn more about the Sheely Law Firm and Bring the Jury. Watch our cool videos. If you miss any parts of this episode or can only tune in for bits, you can always check the full thing uploaded this week on streaming platforms and on YouTube. And with that, I think we'll go ahead and get started. Bryan, or Luke, what's going on with the timeline? We're going to start with Bryan Kohberger today.
Yeah, Kohberger had a little activity last week. We're kind of up against an October 2nd trial date. I think Luke and I had a bet, right?
Yeah.
I think, how'd it go about the trial date? You thought they're going to ask for a continuance because it's a death case and that's what you do because you always need to be more prepared.
Yeah.
And then I was saying, based on the comments and the battles between the state and the defense team, that they were just going to play chicken and try to force the issue. Talking a lot about speedy trial rights and this kind of stuff. And it looks, what do we wager?
A Guinness?
What do we wager? A drink? Something like that? It looks like I owe you a drink because there was a 5-hour motions hearing last week. And one of the issues taken up was the defense seeking a stay of this case to push it back from its October 2nd trial date. And, on a death penalty case, this is already just shockingly fast.
When again were the killings? When did it take place?
Like November of last year.
Yeah.
So,
Less than a year. It's just
less than a year.
We have some of our murder cases are 3-4 years old, unfortunately, but this is really rapid fire. So that was a motion that was requested, and they didn't just say we need more time because we need to, investigate the mitigation side more thoroughly. And this is all in the context of an alibi case, which is, as we've covered extensively, is very unique alibi case on a death case. But they basically, Kohberger's defense lawyers said they wanted a stay because they were investigating and probing grand jury irregularities. Now, they did not use the word misconduct, but they said irregularities, in the grand jury in that area, by law is 45 individuals, and there were fewer than that. There were like 30-something, 36, 38 in the grand jury room deliberating. And so there is a motion to dismiss that's been filed to quash and dismiss the case based on the indictment not being sufficient. Well, you get an indictment out of a grand jury process. But they asked for more time to investigate, and this judge basically said, no, you're not going to have that. Was that surprising to you, Luke? The judge said no?
A little bit.
And it's...
But you're going to enjoy the Guinness nonetheless.
That's right.
Yeah, it's funny, too, because a judge kind of talks like a judge that we're very familiar with whenever a scheduling issue comes up. And this judge basically said, I really want to afford Mr. Kohberger evolve his speedy trial rights.
Right.
We're going to get a little reality check here. You understand? We're gonna enjoy these speedy trial rights. The state has been seeking, a fast trial. There's an Iowa statute that says that all trials must be tried within 6 months. That's all in the context of like
non-capital
cases. So the judge is not when he's saying, Mr. Kohberger, we know you're interested in your speedy trial rights, he's really meaning, screw you. the train tracks are moving forward. The train's coming down the tracks.
The train of justice.
Train of justice. So anyway, so that was part of it, and of course, the prosecutor's idea of any kind of grand jury irregularities. You can imagine what they thought about that. They thought it was delay tactics. And
of course, I mean, based on what we're describing here, that request for a continuance or like a stay it's not necessarily. It seems like dig into irregularities. That's not usually the type of request that gets granted. Something that might get granted is like, well, we have a witness problem, or we can't adequately defend our client per the ADA guidelines unless we can dig into XYZ, prepare for a death case, or it's just kind of fish for something irregular is never really likely going to be doing much for a judge.
It's all record preservation, right? It's all filings. You got to take up this stuff so that the record's preserved. They did have 5 hours of expert testimony, Luke. I want to talk to you about as we talk about the DNA aspect of this case, because again, part of the defense. So the defense had 2 motions, and then the state had 5 smaller-ish motions. The defense main motions were, we need a stay judge to investigate grand jury irregularities. We've got a motion to dismiss the indictment in part based on irregularities, denied. Okay. Our next motion is going to be a motion to compel, and we're going to put up all these experts on the DNA, this special kind of DNA. I'll talk about that in a second, but the prosecution really had a couple things they were concerned with. Number one, what's this alibi? What are we talking about? And, by law, the defense has 10 days before trial to turn over that information unless the judge orders it turned over sooner. So,
I thought they already set a date to have that information in.
Well, normally it's 10 days, but like in this hearing last week, a date got set.
Okay, yeah, for September
8th.
8th.
So that was one of the things that basically one of the state motions was, listen, all this alibi, schmalibi, that's fine if he wants to say he's driving around, but we also want to like close out any like supplemental stuff unless they're complying with alibi notice. And by the way, Judge, we think it's hokey and we think we're entitled to it. And so the judge kind of put that to bed and said, all right, September 8th, which is right around the corner, defense, you have to turn over any and all alibi materials, including witnesses and other evidence, or else you don't get to use it. And so I
hope he went and got a Frosty.
He needs that Frosty. He needs that something. Wendy's late night.
He needs that receipt.
Dollar menu. Small chili. Baked potato. Small baked potato. Chocolate Frosty.
Well, that's right, Hannah. What is Kohberger's late night menu items of choice, given your profile of him?
Given my expertise in reading people and what they would order at a fast food restaurant, Kohberger seems like the kind of guy that would order a strawberry Frosty from Wendy's. Luke added a plain baked potato, which I think is a fair read on this guy. And yeah, just some things that really make your skin crawl.
Like Nightcrawler.
Yeah. If you guys have been following along, he's a dead ringer for Nightcrawler, Jake Gyllenhaal, 100%.
Well,
but I'm unbiased.
He had himself a little face mani-pedi situation going on in court, didn't he?
What?
Trim his eyebrows.
Oh my gosh, did he really?
I think I read some things that he was
trimmed his
significantly trimmed up.
I mean, if I were his defense team, I'd have a court order just on the eyebrows. Wow. Just to make sure they never got out of whack.
They need to throw some glasses on.
Never more than a quarter of an inch in length.
But the other prosecution motions or matters before the court last week, alibi and done. September 8th, turn it over. All right, fine.
So the thing about that is, though, I mean, yeah, they want to avoid any last-second delays like we discussed, any kind of gaming, because it's like no later than 10 days before trial, so certainly a judge can order earlier, but as a defense lawyer, I mean, you're always investigating, just like the state is always investigating. So your client might tell you, I was in this area driving alone at night. It's elsewhere from the incident location, and you might not be able to get that slam dunk evidence until after September 8th because you're waiting on a records request. You're waiting on a subpoena to be complied with, and it's not your fault. But what this judge is saying, he won't let you use it. No.
Well, we've been in that position.
I know, but so it's a difficult situation, and to preclude that in a death case would be tough. But if they're just sitting on the same stuff and they've had it for a long time, the judge wants to get ahead of that.
You know, the funny thing about this is it's such a rush to this trial. And I mean, his death penalty case is going to be tried before a year from this incident of these killings. But if he gets convicted due to it being a death case, the appeals and post-conviction relief proceedings will go on over a decade. That's the crazy part about this. We're rushing to trial with a judge that's allowing these two sides to play chicken. The defense now is asking for a stay. Get out of my courtroom on that issue. And then it's going to be, if it goes down, it's going to be forever.
Yeah, and you really want to do things right when the penalty is ultimate punishment. So, but
Do you find it interesting, and maybe I'm getting ahead of our table of contents,
it's fluid. We can.
yeah, do you think it's they're pleading not guilty as opposed to, do you find that risky, given what we kind of already have at our disposal for evidence, and being that he's up against up against death? Wouldn't you just argue, what are the benefits of just arguing, give him life or a better sentence?
it's a total defense strategy based on the client and evidence. Like we've talked about in past episodes, cases that are just overwhelming evidence. Sometimes you don't.
Nick Cruz
case with our friend Casey Secor. I mean, they pled him, and they didn't do a whole wasteful trial with all these victims and families, and they just did the penalty phase. But sometimes you can offer that, and the prosecutor won't allow it. Or sometimes you can really, if you actually have an arguable case on the front end, on the guilt phase, you can, and here they're going not just like a diminished mental capacity, but straight I wasn't there. Even if it's unanimous, beyond a reasonable doubt, you could have some juror who later on was like, I had a question about that, and how can I kill the man when I, in my own head, was thinking there's a sliver of me that kind of believed he was at that Wendy's with that plain baked potato.
Right.
So you want to have residual doubt mixed up in your penalty phase decision making. So that's one strategy. And unless they truly have an alibi, I've never seen an alibi in a death case. I'm not saying I've scoured everyone across the country to figure it out, but I guarantee you, I'd be willing to bet more than a Guinness, maybe a bottle of bourbon, that it's rarer than the proverbial hen's teeth.
What's the choice bourbon that you would wager?
Woodford? I mean, someone needs to decide this, but I would say there's less than 10 alibi death cases.
You've just said there has never been an alibi death case. Now you're saying fewer than 10.
I said rarer than the proverbial.
I don't even know you're trying to wager now. I'm confused. All right.
So you don't want to take a bet.
Back to the table of contents.
So I think, back to the table of contents. So, and we will do some capital style jury selection questioning maybe at the end of our Kobe segment. Kobe.
Yeah, also that's Kohberger. Bryan nicknamed him Kobe today. This is a new development.
Kobe.
That was the subject line of a lot of my emails that I got today. Kobe. More Kobe.
But more Kobe, please. So alibi is addressed in terms of the timeline. We've got September 8th. These are the state's funny motions. They want to get timelines issued on the right for Kohberger's speedy trial rights. That's the title for their motion. They're very interested in his speedy trial rights. Of course, we got to make sure that we get him to the execution block as fast and efficiently as possible.
Because that's what he wants.
Right. But I love couch at his speedy trial rights, requesting deadlines for pretrial issues. That's pretty standard. But then the real thing here that took up a lot of the time in the hearing last week was basically this new relatively new hit of DNA that the FBI especially was using regarding genetic genealogy investigation. And the FBI is kind of using it to help law enforcement build a tree of family DNA and give law enforcement kind of a leg up in terms of their leads. But then all this stuff is very highly protected in terms of law enforcement. And law enforcement does not want to turn it over. So we want to talk about that for sure. And we'll get to that in a second. But for now, our dates are this. Here are our dates. Trial date, October 2nd. And Luke, tell me if any of this does not make sense to you. October 2nd trial date.
Dates are hard.
Jury selection is going to start September 25th.
Ooh, that does not make sense to me.
That's a short window of time.
Tell everybody why that doesn't make any sense at all.
Well, for most capital jury selections, you have voluminous numbers of jurors because you have to get through so many to get some that are eligible to consider both life and death. And so you have enhanced statutory abilities to drill down on that, to have attorney-conducted voir dire jury selection as opposed to just a judge. You know, a judge can pick a jury in like 30 minutes based on one sheet of lawyer questions that the judge will ask. But statutorily, I mean, most death cases done right when you're picking a jury, especially of this magnitude and this publicity, it would take weeks, 3 weeks. I think.
We've got one.
I mean, it would take 2, 3, 4, 5 weeks, just depending on a lot of variables, but never one. That would be pretty tough to achieve unless you're really efficient. And they've got just a bunch of questionnaires, a bunch of information, and you have to bring in just twice as many, 3 times as many people, and it's just a slower process because the attorneys are doing it and are allowed to dive into way more. And there's not a time limit. Judges sometimes like to put a time limit on it, but that's kind of rare. I don't know how they do this case in a week.
So we're going to talk about the process of selecting a jury. Do we want to get into that now?
Let's hold off for just 1 second. I mean, the last death case you were involved in was what? 2 weeks jury selection? Week 2?
Well,
I think Cruz was
it was
like a
like
5-week jury selection process.
the one I did, which is totally different compared to this, was more like a 7-day jury selection, something like that.
All right.
But that was also Judge Clifton Newman, and he kept us late. Like, we were there picking jurors at like 9 at night, which is really above and beyond to push. He's one of the most efficient judges ever that I've encountered. So, I mean, maybe they've got a judge like that. Maybe that's what they're trying to do, but it's not really good for anybody.
Right. So September 25th, jury selection. So all that process, which we'll do a little kind of mock questioning of that in a little bit here. September 29th, or your last kind of pretrial hearing. And then October 2nd, baby. Let's do this. Come out the block. We've talked about, the motion to stay, but the majority of last week's 5-hour hearing, the defense put up 4 or 5 experts, and it's all on this DNA issue. I'm going to say it again because it's kind of a mouthful. Investigative genetic genealogy. IGG is the acronym, and it's relatively new. The defense is kind of making, assumptions and assertions that it's, so new that, it should be criticized. And it's an investigative technique mostly employed by the FBI to kind of put law enforcement on point. It's been around about 5 years. So our old boss, Doug Strickler, when DNA kind of first came into the courtrooms in South Carolina in like the 80s and 90s, Luke, what did Doug say about that to a Richland County jury?
Send that voodoo back to New York City.
So, anytime you get a new body of science or something that aids a scientific testing process, let's pump the brakes, man. Let's get all the. So like, it was a huge motion to compel put on by the defense because the little part of this type of DNA, the state's really saying it's not analysis, it's not testing. We're just kind of getting you in the right direction. And I want to quote some things here to kind of help our audience really kind of get the right feel for what it is. Oh, it's my stomach growling. So it's used by law enforcement. It's a process where detectives build a family tree based on DNA profiles to zero in on a suspect. So that's kind of the way it was talked about in this database. These, what I call it, it's genealogy that the FBI are using. Like the defense wants it. Give it to us, please. We want to see, like, who else did it put in a profile? Who else did you guys prop up for law enforcement to look at that you didn't? And they also are seeking correspondence, notes, emails. And they put up, and this is how I think the defense did it the right way. They put up a couple experts in the field. They put up a couple kind of technicians. So they had 2 IGG experts as experts in the field to talk about what this is for the court, to build a record, and then a number of attorneys who specialize in IGG kind of discovery processes. And one of them, Stephen Mercer, basically was like, listen, turning over these databases and the release of these IGG records is basically the bare minimum practice standard. So he's saying, listen, if law enforcement is going to have the aid of this process, it's got to be turned over. We need to know what it is. We need to know about who is excluded, who is included. The quote is, the attorney must obtain discovery of the scientific testing of the evidence sampled. And that is particularly so in a capital case, particularly environmental samples of trace DNA. It's absolutely crucial because it informs the scope of the investigation and the experts to get. So he's basically like, we don't even know how we can really start unless we get how they started, which makes sense to me.
Right.
And then, you don't hear a lot from one of Kohberger's co-counsels. This is Alyssa Massoff, and she's telling the judge, basically every single person, and this sounds like something I would say, honestly, every single person in this courtroom should have a pause when talking about forensic science that is no more than 5 years old.
Yeah.
Because, forensic science is peer-reviewed, it's developed, it's got to be, experts don't just get to pop up in a courtroom and talk and be an expert. They have to talk about what they published, how they teach,
right,
where they've been qualified as an expert before.
And that's the expert, but also the methodology for some new science. I mean, it has to be pass muster, has to be reliable. I mean, we've got lots of pseudosciences and even some that are kind of science that have been considered and then rejected by our courts, like polygraphs. Still very prevalent in investigations, but not allowed in court. There's certain things like voice stress analyzers.
Get that out of here! Get that out of here!
We had that. Give it in one.
Get it out of here!
It's literally a crime to give that in South Carolina. They put like a machine up to your voice.
Take that junk science back to New York.
Cracks it. They claim your line. I mean, what was it, like a Scott Peterson trial? There's some trial where there's some hair in a trunk, and the FBI maybe 10 years ago did some kind of hair analysis comparison that was like too weak to reliably get in. So that stuff will come down the pike that you have to assess as a legal community. So 5 years, yes, I agree.
So Ms. Massoff also says to the court, cumulatively, it is overwhelming that we must have this evidence to do the work. And so they put on, 5 hours worth of, this is the good part, not lawyer argument. This is why Luke and I don't have to even hear Luke say this to know that he likes this as well. You're putting a record. You're having experts come on and talk about this body of science. You're having, in this new body of science, people that have dealt with it talk about, that are considered experts in their field, even if they are lawyers, talking about why they need it and why they get it routinely in other jurisdictions. So here is the state's position. Well, you're not turning it over. We're not going to turn it over,
doing that.
And we don't have to turn over.
Why would they not want to turn
And so here, I'm going to read you this quote, and then I'm going to kind of paraphrase from one of my favorite cases, Cowles v. Whitley, but basically, which is a constitutional disclosure case. But so the Idaho discovery rules do not require the state to turn over such records. Counter Jeff Nye, one of the Attorney General's Criminal Law Division prosecutors. IGG, so here's where they get to have their cake and eat it too, does not represent a scientific test, he argues, nor does the information help prove the defendant's innocence.
Well, then...
You kind of don't know until you get it.
That's just their call. They get to make that.
Elements that could require their disclosure. Nye says that IGG is merely an advanced method used by police to obtain an investigative lead. So they're basically saying we don't have to turn it over. And then there's
can the defense just not come back around and use that in court? That even law enforcement themselves are like, well, this stuff it can't really be.
You can always attack the integrity of the investigation, but here's what Nye says as well. We keep on hearing a lot about how this is a death penalty case, and death is different. Like, we should have to turn over this stuff. But discovery's not different. I can just visualize this prosecutor in my mind. I've seen so many of them. Even though I've never laid eyes on Mr. Nye, if the Idaho Supreme Court wanted the rules to be different for death penalty cases, then they could have done that, but they didn't. So, one of my favorite cases, Cowles v. Whitley, talks about disclosure and really, our rules of evidence and our Brady disclosure requires, a prudent prosecutor. Here's the quote that I like so much. If making a choice of turning over evidence or not, they always err towards the side of turning over. It should never be, I love this quote, the private musings and deliberations of a prosecutor. You should always be, wanting to serve the interests of justice, which normally requires disclosure versus, tacking too close to the wind and keeping it held. And, I think that there's a number of other cases that kind of quote that, but to me, it's very important for a prosecutor. This was clearly a big part of how they got to Mr. Kohberger. This new DNA, not a test, but certainly is it something that was able to get them in the right direction. That is only 5 years old, but they're not going to turn it over. And other jurisdictions are turning it over.
Well, you see this a lot, and so you have a prosecutor who has a very narrowly focused argument, but where the rubber hits the road is that local legislatures in a particular state like Idaho are making up a discovery rule about how information is shared, but that never trumps the fundamental constitutional due process rights to a client defendant, where the ultimate penalty is at stake, to confront his accusers, to have a complete and full defense. And a whole litany of constitutional cases on that, and then that's where it will come down to. He has no right to confront his accusers adequately without that information, or show that maybe there was another suspect.
And even though it may not be a scientific test, it sounds to me like it's a data method of compilating, certain DNA profiles. But no one really knows how it works.
He's calling it basically an investigative tool, like Crime Stoppers. Well, guess what? There's no court in the world where if there was 100 Crime Stoppers tips for an incident, a murder, and 2 of them were like my guy, and 98 of them were totally different. Yeah, we get to know about the 98 of them that were totally different. So it's the same investigative lead stuff.
So that has not been ruled on, but they spent 5 hours doing it the right way, putting up experts, educating the court, letting them know it happens in other jurisdictions. And by the way, we've got a firm trial date. We just need this stuff. The defense always, to Hannah's point, has the ability to attack the integrity of the investigation. And so, yeah, I mean, if you don't have how this case started, and you got law enforcement being like, we started with an IGG lead that thanks our friends from the FBI, and well, great, we subpoena all those folks from the FBI. We subpoena, and then it's like, well, how does it work? I don't know. Somebody in the FBI knows how it works. Well, they're coming up next. Let me ask them in front of a jury. How does it work? Well, that's all proprietary, and like we got some guys in another lab that do that. And it's like, well, do you have them under subpoena? No, I don't know who they are because I was never provided this information. You understand? The state over here at that big table didn't turn it over to us. And you get to, utilize those cross-examination techniques to make the state look sneaky. Why not turn it over?
Yeah.
You got a right to know, ladies and gentlemen of the jury.
I mean, maybe they Ozark it and they say that like law enforcement is behind all this.
Ozark it. Wow.
Didn't Bryan Kohberger, didn't he like volunteer with local law enforcement at times?
Yeah.
So they would maybe know him. They would know about him.
Wow.
They'd be like, wow, if we ever, I don't know, went rogue, we would have a prime person to pin this all on. I don't know. Obviously, that's a huge reach, but if you were to Ozark it, maybe there's some corrupt cops in that area that are evil and did something bad, and who knows? Maybe Bryan Kohberger is getting caught up in some bad stuff because he's an easy target. Because he's definitely an easy target. Yeah. He's got the eyes. Apparently, like there's a statistic of like all the people. I like serial killers that like they have the white. You can see the whites around their eyes, like without them opening. Yeah.
What?
Yeah. No, but there's like some crazy statistic that's like if you, I don't know what percentage it is, but like so many serial killers kind of have that physical attribute of being able to see the white completely around someone's eyes, even when they're just like resting, which Bryan has.
What?
Yeah, just like that. The Nightcrawler look.
So anyway, the judge, and I was reading this judge's name. It's like Judge John Judge. Like I think literally his last name is Judge.
Really?
Judge.
He's just born to be a judge.
I like that.
Yeah, and he's like he's talking about reality checks, and we're going to help Mr. Kohberger with his speedy trial rights. And it's like it sounds like so many judges that we've been in front of, honestly. So anyway, he is taking that under advisement, which basically means he's like thinking hard about it, and he's thinking about what I got to do the right thing, but what do we do here? So to be continued on that issue. The last thing I'll say, or I want to talk about a little bit as we close out Kobe.
Yeah, we'll close out the Kobe chapter and stay with us because we're going to get to Rex Heuermann after this.
Just that one of the victim's family members, Kaylee, one of her family members had a bring back the firing squad kind of t-shirt in court.
Oh.
It was like a pro firing squad, just kind of as like a
My mom would do that.
Hey Kohberger, I'm here. This could be your end result. So that was kind of reported on a little bit as being interesting, and so.
Well, she should. Wow. We have that in South Carolina. Really attempt at it.
Yeah. So this is Luke was in Charleston today at our other office, and Hannah was like coming in hot, like, hey, like literally like 30 minutes before we got here, she's like, hey, would it be a good idea to show our audience kind of basic jury selection type questions in a death penalty case? Luke would walk in the door like, oh, I guess I'll need to find some of my own, kind of get up to speed real quick. So, but yeah, I think so. What you are suggesting doing is you'll play an average juror.
Right. I got the letter in the mail that said you've been selected.
You're gonna show up at court, and Luke is gonna play defense lawyer, which he does sometimes, and kind of just demonstrates some of the techniques. And Luke, admittedly, is like, I'm rusty on this.
Oh, yes.
Don't put me on the spot.
You all watching, too, can play along with us. So Luke will be asking the questions, and feel free to kind of drop your responses in the comments. If you were on the other side of a defense attorney trying to see if you'd be a good candidate for a death penalty case juror.
But Luke, why is it a little bit different than a normal jury? How are your questions different? Number one, you get questions.
Correct. Most states have judge-conducted voir dire. even in a murder case where the judge simply is given a submission of maybe a page or two of questions for the jury after some general qualifications to make sure they can read and write and don't have child care issues. And, we've picked a bunch of juries, unfortunately, that the judge reads that little sheet and he decides what he or she wants to ask the potential jurors that they think is pertinent to this murder case, and the state might have some that they think, and it honestly can get done in 30 minutes to an hour, and we're chronically asking for attorney-conducted voir dire, which some states do have. In South Carolina, we do not. But in South Carolina, and in every state that has a death penalty, you do have statutory attorney-conducted voir dire to make sure that you're just going to have so many more jurors because so many more are going to get struck. But the whole point is that you can really learn more about that juror and their biases, their motivations, because the states...
What's wrong with having a bias, Lou? That's just life experience. What do you mean, man?
Well, it's fine to have a bias as long as you're not on my jury, unless you're biased for me. But basically, there's been a revolution in terms of kind of how people are trained to select a death penalty jury, and that's from the good folks out in Colorado who teach a capital jury selection method that has kind of gotten quite popular because it's very effective. And the whole point of that method is to really drill down on someone's views as efficiently as you can on the penalty and the punishment for a murder. And then once you can kind of categorize them to either save folks that you think will be good and be willing to consider life, educate them, save them, keep them on the jury, and the folks that are not willing to consider life and would just convict and give a death penalty upon a conviction, you want to get rid of those people for statutorily disqualifying things. So it's a way to whittle through that. I mean, you could talk forever about it. Go see David Wymore is the guy that invented it, and some other brilliant lawyers out in Colorado, and it's been saving lives ever since. And lots of attorneys like our buddy Casey Secor are quite brilliant and excellent at it. I will give it a go, and I haven't done it in years.
Real quick, Luke,
yeah.
I got a question about the strike system and how is it different in a death penalty case versus like a normal murder case?
Well, it's going to be based by statute for that particular state, but you're basically, you're always trying to get rid of people for cause, and that's why you want to try to get the bad folks, to admit that they can't be fair, that they would, kill somebody because it's expensive to house people in prison, or because they assume that it's automatically, if they're guilty of murder, then they just need to get that penalty, or that they think that if it's not unanimous one way or the other, that it's just a hung jury and you have to redo it again. Well, no, it only takes one in most states to have a life verdict, and that's a verdict. It's not a waste. So, it depends by state, but you're trying to get rid of people for cause.
All right. Well, let's do a quick little. Do we have our general facts, or can I just come up with general facts?
No, basically, you try to make, if you're the defense, you try to make the facts as similar to the case that's actually at hand as possible, without drawing an objection for so-called staking.
So for the purpose of this exercise, what are our general facts?
So for this exercise, she's the juror. Let's just call it it's the Kohberger, right? Okay. That's our facts.
Sounds good to me.
And let's just say for the purpose of this exercise...
Can I be the judge?
Sure.
All right.
That we've gotten through the stage of... Everybody's submitted their questionnaires. Lots of people are being gotten rid of for various reasons by the judge, and now it's time for an attorney-conducted voir dire. So you're going to have basically two teams of lawyers, the judge, and some poor juror just gets called into this courtroom all by themselves. It's called individual sequestered voir dire. They're not with the rest of the panel. They're by themselves. So basically, Hannah, you're the
I'm using my real name, even though I might go into character.
All right, you're the juror who's come in, and everybody has whole spreadsheets about your life already.
Oh, God.
You might not have filled out the
I
questionnaire.
don't think I would have made it this far then.
Right. You don't know that, but maybe you filled out the questionnaire quite well, and I have a certain feeling about you, or maybe you didn't answer any of it, and I just don't know. So,
Okay.
So
you can just opt to leave the questions blank?
Yeah.
Oh, wow. Okay.
I mean, you can't make someone fill out a questionnaire.
Yeah.
But so we start something like this. Like, Hannah, thanks for being here. I just need to ask you some questions about your views on the death penalty, okay?
Okay.
There's no right or wrong answers here. It's just very important since we are in that type of case, okay? Mm-hmm. I want you to imagine that you're sitting on a jury, okay? Not this jury, all right? A hypothetical jury, some other jury, and you and 12, it's a death case, and you and your 12 jurors have unanimously at the first phase of the case found the defendant, the client, guilty beyond a reasonable doubt, okay?
Okay.
And you are now tasked with sitting at the second part of the case, which is what we call the penalty phase. You understand? Mm-hmm. Are you with me?
I'm with you.
Okay, and that's where you and those jurors would decide whether it's a life or death verdict, okay?
Okay.
So you're sitting in this imaginary hypothetical case, not this case, but some other case, and you have decided unanimously that the client is guilty of murder, all right, beyond a reasonable doubt, and it was done with malice in their hearts and evil, okay?
Okay.
Malice of forethought. And that you've considered all the evidence. You've sat through this hypothetical case for a week. You've considered all the evidence, and you've heard evidence that it was self-defense, right? You've rejected that. You may have heard evidence that it was an alibi, that the client didn't do all these heinous murders. You sat, you listened, you considered, you rejected it, okay? You still with me?
Yeah.
You've heard some evidence about perhaps some mental health issues with this guy that did this terrible crime. You discounted it. You didn't buy it, okay? This is not a case of mistaken identity or mistaken fact or even just a mistaken gun going off. Mm-hmm. You and your 12 jurors have sat there through a week of testimony. You've deliberated. You've decided that this guy is a guilty murderer. Mm-hmm. And so now I want to know your opinion on whether death is the only appropriate punishment for this guilty murderer of this innocent victim. What's your opinion?
I think I would need to know more about the situation. I think my decision would be very circumstantial based on who the victim was, how emotionally driven the case was, how many lives were lost, if I believed that this person was going to do it again, what the purpose of this was. Generally, I don't feel like death is the answer. I don't think that that's the right way to rehabilitate someone. But depending on how heinous a crime could be and the safety of other people, maybe even in prison, could be dangerous, and it can be expensive to keep people in prison. So it just really depends for me.
Well, and that's normal. But do you know from a starting position that the state of Idaho is always satisfied with a life verdict? Did you know that? Mm-mm. But they don't require a death verdict just because you found someone guilty of murder.
Okay.
Are you aware of that?
No, I'm not. But now I am.
And to answer some of your questions, these are very natural, but the reason that people under our law can give life is if they find something called mitigation. Do you know what mitigation is?
What is it?
Mitigation is really, it's unique to you and your own individual, personal, moral judgment about the client, about the hypothetical case. And so it might be the way he looks at his mom, and you see a little glimmer of laughter between them when she walks in the courtroom. It might be the way he puts his hand on his defense lawyer's shoulder, or it might just be anything or nothing at all, but it's any reason deep inside your heart that you latch on that you think that somebody is worthy of life, right? Do you understand that now?
Human characteristics.
Correct.
That I feel drawn to.
And it's unique to you because it's your own individual moral judgment. you have had some questions about the expense of whether someone is there, serving a life sentence. Does that make you feel like they're more likely and they should deserve death? Because it does cost a lot of money to keep people in prison.
Well, I mean, that's a difficult thing to answer. I just feel as that, as a former teacher, I could just see tax dollars being used maybe in a different way. If I felt that I didn't believe that this person had anything left to provide our community, or if they were beyond the point of rehabilitation, then I could see perhaps there being a benefit to saving our resources and money.
So if I'm understanding you, I think that if you feel that someone has some redeeming qualities, some rehabilitation openness, that they might be worth life. Is that?
Yes,
okay?
Absolutely.
All right. And that makes sense. Now, do you understand that when you're back there in that deliberation room, that again, we've talked about your individual moral judgment. That is yours and yours alone, right? Mm. Do you understand that you have a right to deliberate, but you don't have a right to have someone tell you how to decide, right? And basically, you should consider the evidence, but once you've made up your mind, you don't have to sit there and listen until everybody else has decided, until somebody has changed your mind. You know that?
Right, yeah.
You actually have a right and an affirmative duty to stand up once you've made your decision and knock on the door and say, bailiff, I need to go see the judge because I've got my decision. It's been made, right? And if you saw somebody else being attacked for their belief, would you feel that they deserve their decision to be protected and honored?
Yes, definitely.
And then in America, we all are a melting pot of different opinions and beliefs, and we're all entitled to that, right? Mm-hmm. Would you help protect that person if they were in the jury room and seemed like they were getting bullied into something and wasn't their verdict?
Yes.
All right. Would you help them knock on the door and say, bailiff, we've decided? Mm-hmm. Okay. Thank you, Hannah, jury. So that's just a little...
Ooh, that was intense.
How'd she do, Luke?
She's good. I would want her on my jury.
What would you give me on a scale of 1 to 7? Because anyone who maybe wasn't listening last week or the week before, there's kind of a sliding scale. 1 being somebody that I guess would never give death.
Yeah, like 1 would be people that would be religiously opposed to death. Mm-hmm. Just would never. They can't allow their religious beliefs don't allow them to judge. Okay. So very likely they would not make it on your jury because the state would disqualify them because they're not open to considering a death verdict. Mm-hmm. 7 is your automatic killers, the ones that think if you're guilty of murder, then death is the punishment. 6, someone who basically wants to give death for financial reasons or other reasons. Mm. There's a saying that if you get a 2 on your jury, then you're in great shape. 2s are really out there. I don't know that I'll put you at a 2. I'd probably put you at a 3. Okay. You automatically, I know you're a teacher. I know you care about rehabilitation. You threw me a little bit of a curveball on, which might have been the point, when you talked about the cost. Mm-hmm. And so I kind of...
Sneaky 2. Maybe like a 3 that can get to a 2 throughout the penalty phase.
This sounds like my Enneagram. I'm a 2-wing 3 or a 3-wing 2.
And so I didn't think that you were going to be anything other than like a 2 or 3, but I wanted to see if you really bit on, it costs too much money and I'm a teacher and I have to buy my children school supplies. Right. So I'm not going to spend, what is it? $18,000 a year for a guy to sit there, then I'd get you off that because if you're wanting death for financial reasons or other reasons like that, automatically disqualifying. If you're mitigation impaired, if I describe mitigation to you and you're like, I don't care about
mitigation impaired. I like that.
That's actual constitutional terminology. If you're impaired to the point where you can't consider mitigation, you can't be on the jury. If you're like abuse, excuse, get off, I'm gonna kill you, boy, then we're trying to get you off the jury. And guess what? If you don't have a jury, you're not having a death penalty trial, and that makes every defense lawyer happy across the nation. So that was a rusty little sample.
No, that was great.
And then you're trying to empower someone that you really want to stand firm on their convictions.
No, I thought that was awesome.
And a lot of people don't realize that it doesn't require a unanimous verdict in the penalty phase, at least in the state where I've been practicing.
I don't think I completely knew that like I could at any time be like, I'm out, I'm done, I've decided, y'all can keep going.
Right.
That could seem like it could get very hostile.
Well, you have a right to deliberate and consider, but you don't have a right to allow them to beat you down and wear you out. It doesn't have to be unanimous. You can walk to that door, and a hung jury does not mean a redo. It means basically it's a life sentence.
And we did have a question while we were doing that, what our own personal opinions were about the death penalty, whether we agree or not. I'll go ahead and start since you guys kind of heard. I did get into character and tried to make it a little bit more, I don't know, fair. But no, I do not agree with the death penalty, and I don't think that I believe that people all have an opportunity to rehabilitate and provide to this world. We don't have to do God's work for them.
Yeah, of course, I don't believe in the death penalty. Every ounce of my body thinks it's ridiculous to punish someone in a way that the state itself says is murder. The most calculated, malicious planning, step-by-step, stage-by-stage punishment. And, it's also, even if I felt like it was a proper punishment, which there's no way it is, and if it weren't so just ridiculous for the state to think of it like that, it's also like disproportionately against minorities that have no means. I know we're covering, high-profile Kohberger case, but like most of the death penalty across our nation has been used against poor folks with rushes to judgment historically, and so it's terrible.
That's a very good point. I'm adamantly opposed to it, and nothing gets me more fired up when I have a case that is scary enough where that might be considered. But I also think from a society standpoint, like there's nothing more hypocritical than the government being like, hey, you're such a bad murderer, we're going to murder you.
Yeah.
Because, murder is nothing but, the unlawful killing of another with malice aforethought. There's nothing more malicious than the government plotting over the course of years, painstakingly, to kill you. And also, we have been around a lot of folks that were eligible for the death penalty, clients, or who death penalty was sought, and you get to know them. I just don't think it's honestly serves a purpose of preventing crime.
Right.
Because the types of folks that are getting into these situations usually, are mentally ill or in a wild panic moment of their life. It's not like in the middle of that moment. Whatever has come to their doorstep mentally, emotionally, that they're about to commit a horrific act, they're not going, wait a minute, maybe I shouldn't storm into this school full of children and kill 30 because maybe I'll get the death penalty. I mean, they're not rational actors all the time. So it just doesn't really serve that purpose to prevent heinous crimes. It just costs a bunch of money. It re-traumatizes victims. Tons of appeals. It bogs down our criminal justice system. So, no, I'm not in favor.
Speaking of death penalty cases and maybe potential death penalty cases, I think maybe we can do a little teaser for next week.
Yes.
We can talk about Rex. Just a couple. I think we can talk a lot about Rex. And who are we talking about, Hannah?
Rex Heuermann. He is are they officially calling him the Gilgo Beach killer? Or are they just associating him with...
Law enforcement is.
Okay, Gilgo Beach killer. And so there's a reason why they're not... Again, we touched on this last week. There's a reason why they're not calling him the Long Island serial killer. Because I guess they haven't connected him to all of those bodies yet. There seems to be a ring with that situation potentially. But I do believe he is responsible for... Well, it seems as though he's responsible for a lot of those. There's a lot of links there.
Pretty soon it'll be the nationwide missing person killer.
Yeah, pretty soon. That's exactly who Rex can be called. So we're going to talk about him next week, but we're going to go ahead, Brian. Give us your teaser.
Yeah, so this is a brand new case, and we'll continue to cover Kohberger extensively because things are really heating up. So everyone that's interested in Kohberger, we're going to be covering a lot as we approach that October date and as we have updates. But Mr. Rex here, Heuermann, is a well-to-do architect out of New York, and he has just been charged with 3 different murders out of the Long Island, Gilgo Beach area. And we covered this episode before last a little bit. Maybe actually it was last. I can't remember. But
all I know is I was sweating profusely on
that was last
on my deck.
But basically, there are a slew of bodies found. Like, we're talking like 8, 9, 10, 11 in this area. And basically, they have been profiling Heuermann for a long time, to the extent, these are all kind of old cold cases, like late 90s, early 2000s, missing persons. Most of these are women. Most of them are sex workers. And basically, they've been, there's a task force that's been basically Rex's task force, and they've been following him, profiling him,
watching him eat pizza,
taking pizza crust out of his local pizza shop and grabbing it up and matching his DNA against hairs in various things found on a lot of these bodies. And boom, bada bing, he's charged with 3 bodies. And he is the suspect numero uno on another one of these Gilgo Beach women. And he's just been arrested, like late July. He, I think last week we were covering.
He'll be tried by August.
Yeah. So interestingly enough, New York does not have the death penalty, and so Luke and I were talking a good bit about the feds. The federal, system does have death eligibility. But you got to meet certain requirements. And so, but they think that this guy is potentially a real, true serial killer.
Do they think that he could be the most, what would you call it, the most killingest?
Prolific?
Killingest.
I like killingest better.
Killingest, the most killingest of all. I don't want to say holds the record. That's weird, but
we'd have to look into that. But
I'm sure someone here watching knows what serial killer out there has the most bodies and what's the number.
Well, we'll look into that, but just for the teaser for next week, so Rex Heuermann, they had a hearing right out the gate with his lawyer. We talked a lot about that in the last episode, who I think is probably grossly misqualified to handle this case. He's just all in the press. He's putting everything about his client on his website. It's terrible. It's unethical. But they had a hearing for his DNA, to actually take a swab from his cheek to basically help with the chain of custody and have a clean kind of connection. Because, they've got DNA from a pizza box, pizza crust he's challenging. They've got other DNA
from Jimmy's calzone.
So now they've got probable cause for a court to order his DNA. That's being done. But they are looking at, his profile. Sex workers. He would take them out for dinner. He would meet them places. They'd go missing. He would call their families on the victims' cell phones and taunt them. But bottom line is, this guy, they found they've got bodies in the New York area. They've got bodies in this beach area. He's got property in Las Vegas. He's got a condo. He's got property in South Carolina, our home turf. Mm-hmm. And basically, they're finding...
Always comes back to South Carolina.
And so
we're like the Kevin Bacon of
So now that they've got
crimes.
this basic MO for this guy, that he killed... Allegedly, he's going after sex workers. He's taking them out. He's getting them in a private location. He's killing them. And he's got these dump sites, allegedly. They're finding these mass, essentially, graves of sex workers. And again, they're coming up in New York, Long Island. They're find some in out west. There's some in Louisiana. There's some swamp with a bunch of unidentified, unsolved kind of killings that maybe fit this style. But I guess here's our teaser for this week. Before we go into it next week, basically near his condo in Las Vegas, just south, there's a victim, Victoria Camara, who was only 17 years old, and she had a child, and she basically was a sex worker, and she was found dead in a very similar style to this. And now that they've got his DNA, local law enforcement in Las Vegas are going to compare it to DNA material found in her body. And so there's basically, the prosecutors are like, this is so eerie. The similarities in these cases are scary. This is the Suffolk County prosecutors like, listen, the type of women that were killed, the occupation, the profile, all this happened. We're waiting on the DNA, but it sounds like he may have killed people out in other locations, like out in Las Vegas, which would be, then it becomes a question, does he kill them there? Does he dump them there? It would seem highly probable that he would go out there and actually kill them. So Nevada may have the death penalty for sure. And then we also may have a situation where what if is he driving? Is he killing? Is he luring across state lines, which always has a federal implication? They're already digging up in his properties in Chester, South Carolina. We'll talk about this more next week as we did the prior week, but he was kind of, a task force was assembled around him because he's very distinctive. He's this very large man with kind of a 1,000-yard stare, and he drove during the time of these bodies going missing.
White eyes.
Right.
Yeah,
he drove an Avalanche truck, Chevy Avalanche, and so it's kind of fit. So they did just tow an Avalanche off of his Chester property in South Carolina.
Oh boy.
And there's missing women in this area. The last thing I'll say, and this was part of the email I sent.
Always South Carolina.
This is part of the email I sent to you that you did some funny reel this morning about all the emails I was flooding you with in your inbox titled "Almost a Skin Suit."
Yeah.
Almost a skin suit. So there is a TMZ interview of a lady named Nikki Brass, and it was TMZ investigates the Gilgo Beach serial murders, and she's like just being interviewed like, yep, I had dinner with him in 2015, and of course she was a sex worker, so he took her out to dinner, wined and dined her, and he just starts in 2015 asking her if she's a fan of true crime. And she's like, well, yeah, I love true crime.
Wait, is this Manhattan? No. Never mind.
This is, yeah.
Oh, it is? Okay, I've seen this. This girl, I think, might be on TikTok talking about it.
Oh, well, I imagine she's talking to everyone that will listen, but she's...
we should get her to join our podcast.
Well, it was called the Gilgo Beach Serial Murders.
Tag her. Send this to her. Send this podcast to her.
Warning signs. Her name's Nikki Brass, and she's basically like, yeah, we were at dinner, and he drove me there, and he's asking if I like true crime. Mm-hmm. Have you heard of the Gilgo Beach murders? Of course I have. I live right around the corner.
And then
she says, basically, he confesses and brags about the killing to the point that it freaks her out so much. Of course, then he asks her, you want to come home with me?
What?
And she's like, no. And so she calls a girlfriend to pick her up, and then he gets angry and storms out of the restaurant. But he's basically,
want to be famous.
Basically admits that, I'm the killer. And so then she's like, yeah, why didn't you tell someone? Well, I was on probation for drugs, so I didn't want to stir the pot. But she's all now like, yeah, I knew he was a serial killer all along. They should come to me. So
yeah, Nikki, come on.
Come on, Nikki.
We'll gladly have you.
But we'll cover Rex, and Nikki's lucky not to be a skin suit. We'll continue to cover Rex, as we will Kohberger and anything else of note, because things tend to pop off in South Carolina.
Things always pop off in South Carolina.
It is.
I wonder if WLTX still have you guys back.
I wish they would.
Yeah. All right, well, it has been another wonderful Monday here. One way that you guys can always support us is by sharing this podcast. You can do it right now at the bottom right of your phone. You can see the little share button. Go ahead and send this to somebody that likes to listen to true crime. They can tune in with us live on their drive home from work or while they're at work. I don't know, wherever you're watching this from. If you missed any bits of this episode and you want to catch the full episode, you can do so this week. It'll be uploaded on YouTube and streaming channels if you want to just listen. But if you like to look at us as well, we're on YouTube. And yeah, other ways you can support us is by following us on social media, Instagram, Facebook, LinkedIn, MySpace,
yes.
YouTube, and all of the above. We really appreciate you guys, and we will see you again next week. This is Ben.
Bring the jury.
There you have it.